You know how sometimes the smallest detail can change everything? Well, today we're jumping into a fascinating legal showdown where a homeowner's right to even be in a meeting came down to the definition of just two little words.
So let's get right to it. Can your homeowners association legally lock you out of a meeting? You might think the answer is a simple no, but it's actually a bit more complicated than that. The answer might just surprise you, and it all comes from this real-life case out of Arizona that shows exactly how the tiniest details in the law can have a massive impact. All right, so our story kicks off in a planned community in Scottsdale, Arizona. And, like a lot of these stories, it starts with a classic showdown, a resident versus the association that's supposed to be running the community. Okay, let's meet the players. In one corner, we've got the homeowner, Gary Moselle. And in the other corner, you have his HOA, the Desert Mountain Master Association. We'll just call him the DMMA. Now that we know who's involved, let's see how this whole thing got started.
So the whole thing really got going back in September of 2017. Mr. Moselle files this petition against his HOA, and then, get this, just 5 days later, the HOA's Communications Committee holds a meeting, and he was explicitly told he could not attend. That one act, being locked out, is what kicked off a legal fight that went on for 8 months, complete with hearings and appeals.
Okay, so now we have to look at the specific state law that was at the heart of this entire fight. And believe me, this is where it gets really, really interesting. At first glance, this Arizona law seems totally straightforward, right? It says all meetings of the association and the board are open to all members. But, did you catch it? There's a tiny little phrase tucked in there that changes everything. And any regularly scheduled committee meetings. The whole entire case is going to pivot on what those two words actually mean.
And that brings us right to the heart of the matter. You've got two sides, the homeowner and the HOA, looking at the exact same phrase, regularly scheduled, and coming up with two totally different definitions.
I mean, it seems like a simple question, doesn't it? What does regularly scheduled actually mean? But the answer to this one question would decide if the HOA broke the law. So let's break down exactly what each side was arguing. So you had Mr. Moselle, the homeowner, saying, hey, regularly scheduled just means it was scheduled in a normal way. You put it on the calendar, you announced it, it should be open. Pretty simple. But the HOA, they came back with a much stricter take. They said, nope, regularly scheduled means it happens at fixed, predictable times, like the first Monday of every single month or once a quarter.
So after all the back and forth, all the arguments and hearings, it was time for the administrative law judge to step in. It was up to them to look at the law and make the final call. So, who was right? Was it the homeowner's broad definition that favors openness, or was it the HOA's much stricter timetable-based interpretation? Let's find out.
And the winner was the HOA. The judge sided with the association. Mr. Moselle lost. But, and this is really important, just knowing who won isn't the real story here. The big takeaway is why they won. The judge's reasoning is everything. The entire decision came down to a core legal idea called the plain language rule. It's actually a pretty simple concept. It basically says, look, don't overthink it. If the words in a law are clear and have a common everyday meaning, you use that meaning. You don't go digging for some secret, complicated interpretation. And that's exactly what the judge did here. She looked at the phrase, regularly scheduled, and said that the plain, common sense meaning is that the meetings happen at, well, regular intervals. It's predictable. It's a pattern. So the homeowner's idea that it just meant scheduled in a normal way got tossed out. And the facts of the case really back this up. I mean, this committee had only met 4 times in 2 years. There was no set pattern at all. But here's the real kicker. In his own testimony, Mr. Moselle himself was talking about other committees that met on an as-needed basis, and he described them as not regularly scheduled. He accidentally used the phrase in the exact same way the HOA was defining it, basically proving their point for them. Okay, so why does any of this matter? What's the big lesson here? Because this isn't just some random story about one guy in Arizona. This is a huge lesson for anyone who lives in a community with an HOA or any kind of governing rules. This whole case is just a perfect example of how powerful specific language can be. It shows that a big, broad idea like an open meetings policy can be completely undone by just 2 little words in the fine print. And that creates a loophole, right? It means committees that only meet every once in a while can legally do it behind closed doors, at least in some places. The bottom line for every single homeowner is this: the exact words in those documents are absolutely critical.
And that really leaves us with a final, pretty powerful thought. This whole legal battle, all the time, all the money, it all came down to the meaning of two simple words. It kind of makes you wonder, doesn't it? What ambiguous little words might be hiding in your community's rules, just waiting to cause a big problem?